15 years ago, the thought of same-sex couples being allowed to legally marry was hard, I think, for most Americans to even contemplate. You probably had to work at the Cato Institute to even wrap your head around that idea.
In 1967, the U.S. Supreme Court overturned bans on interracial marriage in more than a dozen states. The majority opinion in Loving v. Virginia said that marriage is a fundamental right.
There's a good libertarian argument that marriage ought to be separated from the state, something the government shouldn't be involved in. But as long as the government is involved in setting up special legal status, whether that is benefits or simply permissions or licenses, then it should do so on an equal basis. It should treat every citizen equally. And that, to me, is the fundamental argument here, that adults should be able to marry the person they choose.
We all have an interest in protecting individual rights against government discrimination. There may come a time when government gets out of the marriage business, but until government gets out of the marriage business, it is critical that government not be involved in discriminating between certain citizens and certain other citizens.
When the California Supreme Court overturned the state's prohibition on gay marriage as a violation of the fundamental right of marriage, activists responded with Proposition 8. By popular majority, Prop 8 restored the same-sex marriage ban.
In California, you had a very clear example of a right that had been recognized, constitutional right, recognized by the California Supreme Court, the right to marry, that was then taken away by an initiative.
Attorneys David Boies and Ted Olson joined with the American Foundation for Equal Rights to challenge Prop 8 as a violation of due process and equal protections under the 14th Amendment.
Since approximately 1888, the Supreme Court of the United States has 14 times said that marriage is a fundamental right. It's a right of liberty, it's a right of privacy, it's a right of association, it's a right of spirituality.
The Supreme Court has never said it's a right to marry someone of the opposite sex.
When the Supreme Court considered the interracial marriage case, they didn't say it's interracial marriage, they said it was marriage.
Do the states have the authority to say some people will have full rights of marriage and other people will not? The Supreme Court said no in 1967, and I think it should probably say no again.
Even if the Supreme Court reversed itself and marriage ceased to be a fundamental right, the court would still have to show a rational basis for the ban.
One of the things that the court held in the case that we just tried about a year ago, Perry against Schwarzenegger, was that there was not even a rational basis for prohibiting gay and lesbian marriage.
The judge said, well, what harm would it do to Californians or people of heterosexual orientation if people of the same sex were to be married? And our opponent didn't want to answer that question, and he tried to avoid the question, and the judge says, no, answer the question. What harm will it do to heterosexual marriage if people of the same sex get married? And our opponent, who was a very good lawyer, looked at the judge, paused, and said, I don't know.
What is the rational basis for excluding people from marriage to someone that they love who happens to be of the same sex? We keep asking our opponents, and the judge in our case kept asking our opponents, what harm would it do to allow people to marry someone of the same sex? And we kept getting different answers. It can't be a religious background, because we don't allow religion to drive our laws, because that's the First Amendment anti-establishment issue. Our opponents, first of all, came up with the idea that it was to protect procreation. And the judge said, well, wait a minute, I married some people that were in their late 80s last week. They weren't intending to procreate. We have never, in the United States, made procreation or the ability or willingness to procreate a condition to marriage.
Is it the institution of marriage itself? No, because allowing gay marriages certainly doesn't preclude heterosexual marriages. There's no diminution in the extent to which people who are heterosexuals can get married. Is it child rearing? No, it's not. There's been a massive amount of evidence introduced that children are raised quite successfully in gay couples, and where there's no difference between being raised in a gay couple and being raised by a heterosexual couple.
Because it's always been that way is not a rational basis. So I've yet to hear anyone articulate to me what the rational basis is to exclude a portion of our citizens from a right, whether you call it a fundamental right or not, that other citizens are able to enjoy.
The time is right, just as it was with Loving, the anniversary of which we celebrate on June 12th. What you have is a recognition, I think, increasingly, that gay and lesbian citizens deserve the same equality that all other citizens deserve.
People are demanding their rights now, and people don't get their rights until they stand up and demand them. Nobody said, let's do a case on eminent domain in 2005. It's just that Suzette Kilo's house was taken and she didn't like it. And she called a lawyer, and that's what caused the Kilo case. Nobody said in 1969 it's time for gay people to stand up for their rights. It's just some people at the Stonewall Inn suddenly did it. And Jim Crow had been the law of the land for decades when the Freedom Riders in 1961 decided to challenge it by taking a bus ride through the Deep South. And once people do stand up for their rights, then sometimes other people notice and say, yes, that's wrong, that's unfair, that's immoral, and people get their rights.
What if you were told by your government that because you came from a certain national origin, that you could be all the things that a citizen could be? You could vote, you could travel, you could own property, you could do everything, but you couldn't call yourself a citizen. You wouldn't be a citizen. And if you can't be married in this country, you are being left out of a very, very important component of what our society respects and reveres. And we are telling people, when we put a restriction of that nature in the Constitution of the state, the biggest state in the United States, that it's okay. These people are different. They're not entitled to the same respect. They're not entitled to the same dignity. They're not entitled to equality. They are separate, and they are different, and they're somehow second-class citizens. They are not the same. They are not okay. And that is a state-instituted license to discriminate, to harass, to bully, and to do great damage. That's what we're trying to overcome, and that's what Proposition 8 case is all about.